Someone else can talk.
Okay.
Okay, and I'm okay. Okay. So a number of issues had come up regarding at least the initial set of disclosures regarding conflicts of interest that Gibson Dunn had provided in its initial application. So we are now sort of doing some follow-up on that. Now, I know Commissioner Ward, who's on another committee, has something to read, but maybe we should start with Mr. Miller's report, which shouldn't take too long, and Commissioner Ward can chime in.
Very well. This is a follow-up from the last meeting of this committee and the full commission, at which time I reported to the full commission that we had requested information about additional information relative to the conflict of interest provisions of the government code that are applicable to this commission. And the firm has responded as requested. Their response has been posted to our internet site and provided to the commission. I also have copies of that available today if it would be helpful to anyone. There were two matters in particular that were the subject of the disclosure. The first is any lobbying activities on the part of the firm or its lawyers. And what they have advised is that neither the firm nor any lawyers are registered lobbyists in California. The firm has undertaken some lobbying activities in Washington, D.C., and has provided the names of those lawyers that they believe have done that work. It appears that every time the federal procedure for reporting lobbying appears to be different than that in California, and it's not unlike other governmental processes that are complicated. It appears each time a lobbying activity occurs that is reported, so that the name of the firm and the lawyer in the firm that has engaged in lobbying is recorded, and they've provided that information. I think the most useful information, however, as it relates to our consideration of the firm, is how the magnitude of that work compares to their overall work as a percentage. And the answer to that is that it's a fraction of 1%. So it's not at the heart of what they're doing. It's from a firm perspective, I think it would be fair to characterize it as a tangential activity. The second thing to look at is who the work has been done for, and they have provided that list, and it is this is my characterization, business as opposed to political or public entities. Examples are Ticketmaster, Pacific Maritime Association, United States Chamber of Commerce, University of Maine. I'm just pulling these out randomly. Boeing, General Electric Corporation, but they're all posted on the internet, and I think those are representative of the types of entities for whom they've done lobbying work. The other issue was contributions to candidates. They have reported that none of the lawyers assigned or who would be assigned to work on behalf of the commission have made political contributions that would be covered by or would have to be disclosed as a result of the conflict provisions, again, that apply to the commission and its consultants. They have, however, the firm has made political contributions, and they've done that through what's called a Political Action Committee, or PAC. A PAC is a creature created under the federal election law pursuant to which a company or a law firm or any individual for that matter may register a PAC with the Federal Election Commission, and so doing permits the PAC to make legal political contributions pursuant to federal election law, which has disclosure and limits associated with it. So they have done that, and that's how the contributions have made. The next question would be, to whom have they been made? And again, the specifics of who received money from the PAC is part of the disclosure, again, is posted and provided to the Commission. They have been made in what I'll style as an egalitarian way, that is, contributions to Democrats and to Republicans are very substantially equal. And the contributions have been made, I'm referring to California contributions, they've been made at the gubernatorial as well as 2 or 3 contributions to candidates for Congress, as well as candidates for the Senate and for Attorney General of the state, as well as to both political parties. Again, all of those have been listed and provided to the Commission. So that's the follow-up in terms of the information received as a result of the Commission's request from the last meeting.
So, a couple of questions, Mr. Morello. Do we have any sense from the firm regarding the control of the PAC, and more specifically, do any of the attorneys that are specifically listed as the ones who do the work for us, are any of them, do they have any influence on the donations of the PAC, or?
Well, they're not. When a PAC is formed, it establishes what I'll call a management committee. There may be a technical term that's different than that makes the decisions on behalf of a PAC. These lawyers are not participants at that level.
Okay. And I wasn't entirely clear from having reviewed the House and the U.S. House and the U.S. Senate lists. Is the firm itself, because I know a number of the individual attorneys are listed as lobbyists, but on a number of the listings, it's just sort of the firm listed. Is the firm as a whole considered a lobbying firm? That was my impression, but wasn't quite sure about that.
Yeah, I followed up on that question for you, and I think what I'll do is read the response that I was given by the firm, so that there's no interpretation involved here. And the response is, our supplemental disclosures say that there are hundreds of results in the federal lobbying database where Gibson, Dunn, and Crutcher attorneys registered as federal lobbyists. Technically, registrant name, in quotes, is Gibson Dunn, and there's a separate entity for lobbyist name, the individual attorney. And I asked again why there were so many, and my understanding was that it's not that there's so many entries, it's not there's so many lawyers, it's because each activity is registered.
Okay. Are there any questions for Mr. Miller at this point on what he's found so far, or at least what's been submitted in the disclosure? Okay.
He said that there was available. What do you want me to say?
This microphone.
Okay.
Get your name.
Just get my name. My name is Jeanette Sahi.
Could you spell your last name, please?
S-A-H-I.
Thank you.
Okay. Thank you.
Yeah. Okay. Yeah, I think Commissioner Ward and I were just observing there's sort of a high sound. I think maybe it's the sound system or something that we're picking up on. Is anyone else hearing that?
I'm okay here.
You're okay there. Mr. Ward's young perceptive ears are they're still working pretty well. Good. Okay. Well, This is, I think, a challenging question for the committee and the commission, because we have adopted a policy regarding the conflicts that are in Section 8252 that we're not applying the same standards that had been applied to commission selection. In other words, any of these criteria that have been listed, if any one of them are in the affirmative, then you wouldn't have been eligible to be a commissioner. So basically an automatic disqualifier. We've basically taken a position that we will, in fact, apply these criteria to the extent applicable, both to staff and to consultants. And I think for us, our task is to make some decisions and make some recommendations to the full committee regarding whether, if at this point we feel the disclosures are in fact complete, in other words, there's nothing else that would need further disclosure, and two, given what has been disclosed, while again, if you strictly read some of the criteria for conflicts would be disqualifiers, whether given our discretion under these kinds of circumstances, whether these are either problems in terms of the selection of Gibson Dunn, or would it rise to a level of actually being a disqualifier for anybody. I have my own comments, but if Commissioner Forbes, if you want to chime in, and other commissioners as well.
Well, I'm glad that we had the opportunity to get this extra data. Of course, I would have liked to get it at the initial time, but we didn't get it. I do appreciate the fact that the supplemental material has been, I thought, quite thorough and quite clear. To my mind, the nature of their lobbying and their political contributions don't rise to the level of a conflict of interest in any way that would affect our work. And so I'm content with the decision that we initially made.
Okay. Any other? I'll go last since I'm sort of chairing this one, but others can chime in. And I think Commissioner Filkins-Weber transmitted something via email, and I think Commissioner Blanco as well. I'm not sure if these are all posted at this point, though.
Their email messages have not yet been posted to the internet, but they will be.
Okay.
And
these just came in.
I did print them out, and they're available if one of the commissioners would like to read them in the public, for example.
Yeah, we'll read them.
That'd be fine.
Okay. You want to cover Commissioner Filkins-Weber?
Thank you, Lee. Sure. I'm standing in for Legal Subcommittee Lead Commissioner Filkins-Weber, and she sent the following response. Dear Commission, in my absence from this week's meetings, I wish to advise you, as the lead of the Legal Advisory Committee, that I have reviewed the supplemental disclosure from our VRA attorneys, Gibson, Dunn, and Crutcher. In doing so, it is evident that their, quote, lobbying, unquote, services were at the federal level and appear to be on behalf of private companies. The disclosure alleges that Gibson Dunn has not been a registered lobbyist in California. In regard to their political contributions, it appears the firm's contributions have been to political candidates who hold office following elections in districts at issue in our redistricting efforts. However, it appears the contributions were made equally to politicians and candidates from the Democratic Party and Republican Party. Further, the amounts paid to those presently holding office do not appear to be significant to warrant criticism that such could result in undue influence by any such politician in the nature of our proceedings by virtue of the firm's representation of the Commission. Finally, it should be noted that although this supplemental disclosure states that the 4 identified attorneys to provide services to the Commission have not been registered lobbyists, the supplemental disclosure fails to mention whether any of the 4 attorneys made any personal contributions of $2,000 or more to any congressional, state, or local candidate for elective public office within the last 10 years. I have asked Mr. Miller to make inquiry of Mr. Brown and or Mr. Kolke regarding this issue and trust he will advise you of his findings. Should there be no issue with the personal contributions, time is of the essence, and I recommend that we move forward with the previous awarded contract to Gibson, Dunn, and Crutcher. Thank you. Commissioner Jody Filkins-Weber.
Thank you, Commissioner Ward. And do you have any personal, because I know you have to go to the other meeting as well. Is there anything you wanted to add as a personal statement?
Thank you.
Okay. Let me read, and this is an email, again, this just arrived within about the last hour from Commissioner Blanco. Dear fellow commissioners, I unfortunately am unable to attend this week's business meetings of the Commission and the Legal Advisory Committee meeting due to illness. I wanted to share my views on the Gibson-Dunn disclosure and our retention of the firm to act as our Voting Rights Act counsel. I believe we should continue to retain them for the following reasons. 1. While the disclosure came late and we had to ask for it, it is extremely detailed and complete, and I believe we now have all the information we requested. 2. Of all the disclosures, the only one that appears relevant for the purposes of Gibson-Dunn doing our legal work, as opposed to line drawing, is the fact that the firm has a PAC that is donated to 3 California congressional races, 2 Republican and 1 Democratic donation. The PAC appears to be a separate entity from the LLC Limited Liability Corporation that receives contributions from lawyers in the firm and then makes decisions as to how to disperse the money. I do not see this arrangement as having an impact on the legal advice the Gibson-Dunn team will provide for the Commission. Our 5-lawyer team, I think we're dealing with a 4-lawyer team, 5-lawyer team, literally, is part of a 900-lawyer national firm, and from the disclosures, it appears that none of the members of the team have been lobbyists in D.C. or California or contributors to the PAC. If the PAC's contributions concern us, we can make sure that there's no communication or information sharing between the separate PAC and our legal team. 3, we have received comments about the Voting Rights Act expertise of our team. I'll continue reading these, even though this is a somewhat separate issue. I'm confident that the team's experience with the California Voting Rights Act complies with the requirement that we hire counsel with Voting Rights Act experience. The analysis for determining whether at-large districts in California dilute minority voting power is completely analogous to dilution law under the Federal Voting Rights Act. Also, Mr. Kolke does have federal redistricting experience, something overlooked by the comments that we have received from local quarters that seem to believe that our only attorney is Mr. Brown. 4, finally, I do not believe that Gibson-Dunn's lobbying in D.C. on behalf of corporate clients is comparable to the Nielsen-Merksimer firm's close relationship with the California legislature and its members. Even today, a description of the Nielsen-Merksimer's practice on its website states, quote, many of our senior attorneys have held top positions in California's state and local government for elected office holders of both major political parties. Others have served in important elected or appointed positions. As a result, we have a thorough understanding of the governmental process at every level and are able to anticipate and resolve issues arising in the legislature and administrative and regulatory bodies. Our experience and knowledge of important public policy issues allows us to maintain open communication with top officials in the executive and legislative branches of California government, as well as the state's major business, industry, and labor associations and local governments, close quotes. In contrast, the core of Gibson-Dunn's work is not political or legislative. It is commercial and, in fact, appears to have very little connection to Sacramento or California politics. Having them as our counsel does not create the appearance of having hired a, quote, political insider, close quote, firm. In fact, I believe that Gibson-Dunn's reputation is that of a high-quality national firm that happens, in parentheses, luckily for us, to encourage its attorney to do pro bono work, and therefore has a team of attorneys familiar with and practicing in the area of voting rights and redistricting. Sincerely yours, Commissioner Maria Blanco. There's something else. So that's the end of Commissioner Blanco's email to us, and again that'll be posted as well. Any other commissioners? Again, I have something to say, but any other commissioners want to say anything? Well, I agree with generally the sentiments that have been stated so far. I was disappointed that some of these disclosures were not made, particularly the federal lobbying one, which seems to be somewhat obvious. You should know what's going on in your D.C. office. But I certainly don't think that the failure to disclose has been, I think, rectified by the supplemental disclosures. So I'm not too concerned about they're not at least doing the initial homework that they should have done. In terms of their actual disclosures, I agree with other commissioners and other statements that, at least in terms of the lobbying activities, there really isn't much going on in California. The federal activity is pretty significant, but for the most part does not involve, from what I can tell, any problems in terms of direct conflicts with their representation of those clients in Washington, D.C. based lobbying with any of the work of the Commission. So I don't see any sort of specific conflicts of interest. Again, this is one of those criteria where, again, if this were a candidate for commissioner, lobbying or being a registered lobbyist would be a disqualifier. Lots of law firms do this as part of their work. It's not too different from litigation in terms of representing a particular interest. It doesn't seem to be a very significant part of their overall work. It's largely, in terms of the federal work, confined to their D.C. office. And so that, just by the nature of its lobbying, to me seems to be not a problem. With respect to donations, again, I think that obviously they have a PAC. They should have known that the PAC wasn't in existence, and the PAC gave pretty sizable donations. I'm happy to have what Commissioner Filkins-Weber has suggested, which is another query, but my understanding is that I think they have pretty much disclosed that they don't have any above 2,000. So
you're correct. We do have that information, and they've not given to any California candidate in the amount of $2,000.
Right.
From those lawyers working on our account.
Now, these, if you look at some of the PAC donations, they're pretty big, but this is a big corporation. I mean, they have, according to Mr. Brown, for the past calendar year, over $1 billion in revenue, and they are complying with PAC regulations in terms of their donation levels, and even though we're not necessarily saying, well, how many Democrats, how many Republicans, it seems to me that they're taking an even-handed approach, that there's no sense of impartiality because they're sort of skewed heavily in one direction. So I don't see a problem in terms of partisan bias in that sense. So I'm pretty satisfied at this point. In fact, we do have everything at this point. I'm hoping we have everything that we need to look at, that the disclosures are sufficient. And, I think one thing that's important to stress both, within the Commission and to the public is that, at least in my mind, even though, again, these criteria would be disqualifiers for Commission selection, they're not automatic disqualifiers for our staff and our consultants. We do look at them carefully, and I think that's what we're trying to do in terms of the specifics of this particular consultant. But I think as applied to the other law firm that was sort of a finalist, the other candidates for the Voting Rights Act Council, as well as for other consultants that we've been looking at, that we're trying to be even-handed, that at least for me, I did not disqualify the Nielsen Merksimer firm, for example, because of the fact that they were lobbying or had a lobbying record for various Republican candidates or for the Republican Party. But that was something to look at in terms of both in terms of perhaps ranking as well as qualification, but certainly did not disqualify them outright based on either lobbying activity or donations. And that's still my sense today, is that at least our candidates that we have looked at in the past they're not so skewed in one direction that either lobbying activity presents a direct conflict or a general conflict, nor do their donations actually present much of an issue either. So, yeah, Commissioner Ryan.
I'm sorry, I think I'm always setting that thing off. I think it's important to constantly reassure the public about how the Commission looks at these conflict issues that have come up. I think it makes sense that the commissioners, we ourselves, were subject to perhaps a higher standard because we're the decision makers. But I think it's also important for the public to understand that we are looking at our advisors, for looking to them for their expertise, and it's not unexpected that there would be potential conflicts in their experience. But to just remember that it's the Commission that's going to take whatever advice we're given and make the decisions. And so any concern about differing standards or anything like that, just doing as much as we can to allay those concerns.
Any other commissioners want to chime in at this point? Commissioner Barab?
Just to reinforce the point that Commissioner Raya made, is that when we get advice and counsel, when it's going to be in a public meeting, And to that extent, it's everybody gets to hear what we're being advised on as well.
So, Mr. Miller, I mean, just procedurally, although I guess Commissioner Forbes and I could be the committee make a recommendation to the full commission, but just for outlining where we had sort of put the brakes on for a little bit to get this information, and obviously wanting to move forward in the process, where are we sort of moving toward?
I would like to make a suggestion about that. Remembering that at the prior meeting, the commission voted under the provisions of what I'll call the special majority rules to retain the firm. And that motion is still in place. The commission just asked that we do some additional diligence on the measures that we've just discussed. With that in mind, and if it's the sense of this committee that we ought to continue forward with the firm, I think the easiest and cleanest way to permit that to occur would simply be to make a report back to the commission that the disclosures were received and reviewed and discussed, and it is the sense of the commission that we should continue with the law firm. In that regard, if the commission were simply to, one, accept the report of the committee, and two, authorize staff to go forward and enter into the legal services contract on the terms that were discussed, I think that would properly conclude the matter. There's not a procedural need to vote a second time on the firm because nothing has occurred other than additional inquiries since that occurred.
Just, if you could refresh my memory, we did authorize a under $5,000 contract, at least while this was still pending, for them to engage in some work. Is there any effect? I mean, just in terms of work that would be subtracted out, let's say, from the original contract versus what has already been sort of covered by that small contract.
That's a fair way to say it. I think a better way to say it is that the maximum amount of the totality of the service is unchanged at $299,000. So, to the extent, okay, let me come back and address that. We'll just hold that number. What we received from the firms were estimates of work. Everybody said what they could do for $150,000, which was our target. No firm really offered complete package of services that gets us to the finish line at $150,000. We since, as a result of those discussions, I went back to Gibson Dunn and worked on a much more detailed work plan that includes a final report, which is the key document for all of our work. It's difficult to know the exact number of the final bill because this is work that has never been done before in this manner. The key drivers for both cost incurrence and cost savings are essentially the same. One is how many meetings and how long the lawyers have to attend those meetings of the commission, and two, the successful collaboration of the VRA lawyers and the line drawers. So in that regard, we're trying to drive the costs down by a couple of things. One is the way information is collected at public meetings. To the extent that that can be categorized and summarized and relied upon on an ongoing way, the total cost of the lawyers will go down rather than having to do a document dive, if you will, into those details, which is you know how lawyers work, that's a potential driver of a lot of hours. At the same time, we see it as our best opportunity to reduce total hours. And of course, obviously, personal appearances are time intensive, so we're trying to tee those up in a way that limits them. Well, having walked through that with the firm and then having brought the firm and Q2 together on a preliminary basis last week to try to foster that relationship and begin a productive way to do that efficiently, that's the number we came up with. Also recall at the end of the last meeting we invited Mr. Claypool to come over because we were concerned about costs. And $299 was about the top that he felt we could absorb in our budget and take care of everything else we need to do. With that in mind, we did not choose probably the least expensive firm, given the way national firms of this size operate. We chose a firm that is giving us a deep discount against their usual rates, which are much higher than those of us here are accustomed to typically working with. But you wrap it all up, and that's the number that we recommend be used as a not-to-exceed number in this contract.
And I don't know if that figure had been reported out to the full commission or had been conveyed via staff or via the leads to the finance advisory committee. I do recall now the number being tossed out by Mr. Claypool at a previous meeting, but it's something that I think the full commission would like to probably get a chance to talk about, if that's appropriate. I would think that the commission would want to say, because that is significantly higher than at least the initial budgeted amount, but again, not unexpected that we would have to go higher. I think everyone sort of knew that.
Well, it is higher than we had expected. That's why we reconvened at the end of the discussions about the lawyers and asked Mr. Claypool to come over so we could have a discussion specifically about the budget. And that did occur in this committee and not with the full commission. Right.
Okay. Well, just in terms of moving forward, I think it would be a sense of the committee that we could report back in terms of specific. And the full commission has in fact received, and the public has available to it, the supplemental disclosure statement. The more specific data, I think, has to be looked at online.
It's available.
It's available online. If you actually want to look through the full list, you do have to go online. It's not all within the disclosure statement itself. That we can report back on that, and then perhaps as a staff report, you can report to the commission your prior discussions over the past week or so with Gibson Dunn, and let the commission know where things are at. And have they provided a written sort of work plan, or is this sort of orally provided to you? Or?
This is as good a work plan as I've ever seen. Okay. It is a written plan, okay. And of course, every hour is an estimate, but it is worked out from start to finish in a comprehensive.
Is that a document that you could release, provide to us? Or?
I can. I don't think it's in your best interests. In what way? We could easily spend the rest of today and tomorrow in the form that we sometimes do, asking whether 40 hours is the right number. Maybe it couldn't be done in 27.5, and the answer is yes. Right. It might be, but these are people who have spent a lot of hours doing their best to say, I think this is what it's going to take. Okay. And what I can tell you is that it matters. So I think the commission did an excellent job in scoping this work prior to the time we interviewed the law firms. You'll recall as a committee we went through and we said these are the categories of where we think we need legal services. And that's the foundation for the budget, is those categories that this committee put together in anticipation of the interviews.
Okay. Well, given the level of detail, I think it would still be useful to have the commissioners receive the document to get a more detailed review. It may be more useful, though, to sort of summarize where things are with that figure. I know Commissioner Ward is a member of the Finance Committee. I'd like him to comment if he would like to, in terms of what would be useful for sort of the big picture sense of where we are with the budget. So, and I'm happy. I'm satisfied if you think that the plan itself may be too much to go through on a line by line basis. But as long as we can get sort of general sense of where it's going and why it adds up to basically close to 300,000. Which I think other commissioners will ask, of course, well, how did it get to be this number? And as long as those, and we have to trust your judgment as counsel as well, that getting our money's worth with that figure. But I think we want to have some degree of examination of where things are being spent. Commissioner Braba.
As I understood, it was a not-to-exceed number.
That
means we don't have to spend that amount. And it seems to me that's where we hold the staff's feet to the fire, that every penny we spend is what we need to spend it on. And that sense gives me a more comfort level that we haven't signed a contract to spend exactly that amount. Given the amount of uncertainty that's associated with this process, I think that's probably a reasonable way to think about it.
Commissioner Ward.
Thank you, sir. Yeah, I kind of concur with Commissioner Braba's point. I think the Commission's done its due diligence in expressing that their desire for Mr. Miller to kind of lead up the effort to come up with that work plan and to work with the lawyers diligently to make sure that that the scope that we set out is met adequately and efficiently. And it seems like that's also certainly an appropriate thing to bring to the subcommittee, but between the subcommittee and our legal counsel, it seems like, that's, at least as a full commission member, that's all I care to see. If you guys have got it, and then on the finance, we know what your not-to-exceed number is, so we can make sure that we do everything we can to get it, and that's it. I think as a commission, sitting on the commission at large, I trust that the subcommittee and our chosen staff, legal counsel, can manage the details.
I do think it's important for this committee to know, because it might not be evident, that they're having a budget meeting across the hall concurrently with us, and that number will be used in that meeting as it relates to the total expenses for the commission.
No, that's great. And we also have Commissioner Ward can shuttle back as well to confirm. But I think as part of our report, we can certainly indicate, and you can of course be part of the report, that this is the work plan, this is the dollar figures, and if there are any individual questions that come up, they can simply be addressed at that point.
If I could continue this theme for just a moment, we're concluding today the contract with Q2 to perform their services, and it's been somewhat like swimming through quicksand to accomplish what doesn't seem like it should be that hard. But it is in part because of the complications of the state contracting system, and also, frankly, because of working as closely as we have throughout that with the Commission, and in addition, a commissioner actually being delegated to sign the agreement. That commissioner is unfortunately not able to be here today. So what I was going to ask is, keeping in mind we have, with respect to the legal contract, a not-to-exceed number based entirely upon a work plan that was developed by this committee. If the Commission would, on that basis, be comfortable delegating to staff the authority to enter into the contract on those terms without bringing additional terms back along the way to the Commission for approval. The reason is we don't have another business meeting until the end of the month, another scheduled business meeting. The need for finishing this contract and bringing the lawyers on promptly is urgent. And the foundation for the contract has been, I think, very well established by the Commission. But that would be a different form of motion than was used for the line drawer contract. So, did you have a question?
No, I think as long as we're following correct procedure, and I should also note that Chairman Antai is with us here as well. Is he actually going to be the signatory on the? Would he be the signatory on the contract, or is it?
He can be. You can have anybody do that, but typically, let's say if this was a city council, you'd have perhaps the city manager sign that contract rather than a member of the council. And we're here in Sacramento, and I just think it would be helpful to the Commission actually to expedite this, given the information that you have, if you could delegate to staff the responsibility for completing and signing this agreement.
Well,
that would be a recommendation to the full
commission. Okay, that's fine. And I think, and we're also taking this up as part of the full commission's business this afternoon.
That's right. We wanted to first make sure we accomplished our Public Records Act and other training, and then really I believe the only other item on the agenda in addition to that training is this item. So there'd be an opportunity this afternoon to report back and conclude the matter.
Okay. Sounds like a plan. With respect to the Gibson-Dunn contract, sounds like a plan at this point. Mm-hmm. Commissioner Antai.
I just want to go back to the issue of the scope of the work. As an architect myself, we generally use a not-to-exceed number, especially when we're dealing with scopes of work that are undefined. We're dealing with a building that needs major remodeling. We really don't know until we break in a wall and find out what's in there. And, if it's a horrible condition, then we just have to pour in a lot of money, both engineering work and documentation, to get that through the city permitting process. This project, I would imagine, has many unknowns that as we go through the public input hearing process, there might be a considerable amount of demand on our VRA attorney to document that and to give us the appropriate response for the commission to consider. So there's a lot of variables and unknowns, I think, throughout that process.
Are there any further comments on this issue? We do have a couple other agenda items as well. Are there any members of the public who want to comment on this particular?
Hello, Commissioners. Is it on?
A little closer. You can just move it closer to yourself.
It's not that. That's what it is. Sure, this one. Okay. Hello. Okay. Sorry.
Please give your name and spell your name.
Yeah. Hello, Commissioners. David Salaverry from Berkeley, Salaverry. There's a lot going on here today with the Gibson-Dunn matter. And unfortunately, I've only gotten the background information with their disclosure a few minutes ago, which I've gone over pretty briefly. I'm a little concerned that there was one page that does not list the totals in terms of the Republican Democrat. I would like to see that. I think you guys are aware that Mr. Tony Quinn sent the commission a letter basically stating that Gibson, Dunn, and Crutcher has a lot of problems. MapLight came out with some information about them, which I guess is in their disclosure. So I just wanted you to make note of that. You received the letter by email. What I'm seeing here is that Attorney Miller saying that we don't know the cost of any of the bidders is not accurate as far as what I could tell being here in the commission hearings. It seemed to me that Nielsen Mercksammer was clearly much less expensive than any of the alternatives. They had much more bundled into their package. Their numbers were harder in the first place. And I'm not hearing about how Gibson is doing us a favor by lowering their $800 to $900 an hour rate to $350 an hour as being a wonderful deal for the commission, especially now that the total budget has crept up to $299,000. That's a significant amount of money. I know that on a separate thing, you guys are probably going to go back to the legislature and try to get more money to fund the commission, but I don't see that as being something that the legislature is going to look at with a great deal of pleasure, seeing as California is in some very, very dire straits financially. So I think that you ought to open this up back to Merksheimer, and if you want to bring in the folks, the letter from the African American Redistricting Collaborative and the Asian Pacific Legal Center and the National Association for Latino and Elected Appointed Officials, basically saying that you ought to hire Anna Henderson, that you ought to hire, well, I'm not getting to the bottom of this quickly, but if you want to open it up, completely, I think that, might be fair. And I think that we need to have more of a political consideration here. The full committee, basically went with what, the folks, on the conservative side consider to be the Democrat and the liberal candidate, for the line drawing, which is Q2. And I don't see any reason politically why you guys couldn't open it up then to a firm like Nielsen Merkshammer, which has been in some ways identified with the right. And I think that would create some political balance that you guys don't have at all. And for the liberals and the left to be at this point, with possibly Gibson Dunn going down in flames, trying to bring in even further people to the left, I think is frankly outrageous. So that's the end of my comment. Thank you.
Thank you very much. Are there any additional comments at this point? Okay. So again, just to summarize, we will report back to the full commission regarding both the disclosure statements as well as the discussions that Mr. Miller's had with the firm, and if there are any additional inquiries or any changes to the existing policy, which is that we're going forward with this firm, we'll take that up with the full commission.
Okay. If you don't mind, I'm going to join the Finance Subcommittee in progress.
Not at all,
Thank you,
Mr. Ward. Thank you very much for joining us. We appreciate your splitting time. We do have a couple other items on the agenda, and let's just sort of take them in order. Now, is there anything else to cover in terms of coordination of work between Gibson Dunn and Q2 that you wanted to report on, Mr. Miller?
I think it's worth a comment, okay, because, as I say, it's really at the heart of how this work goes forward. It will be our strong desire to coordinate that work closely, and I think that can be done with less than the full complement of lawyers at any meeting, like one as opposed to four. I think we need to do a little bit of work with Q2 to help them understand the benefits of that, in that it just doesn't seem like a manner of undertaking the work that they've had to do in prior undertakings. So that's going to be at the heart of my focus in the near term, is trying to nurture that and develop a regular way for the two to talk and lay the pipe through that process of baking in the public input on an ongoing basis leading up to the final report. At the end of the day, that's what will permit the Commission's maps to survive challenge, and I think for the same reason that's where we want to be focused right now, is approaching the task in a way that delivers the very best result in the final reports, and that's that ongoing communication. So I can report back at future meetings about how it's going and how we're making it work, but that's the thing to keep our eye on.
Okay. Any questions for Mr. Miller on this point? Excuse me. Okay. So the next agenda item then, maybe an update regarding the Q2 contract, and I know there had been some discussion, and I think we'd asked you to do some additional research regarding what we've been calling the firewalling of one of the partners of Q2. But if you can give just a more general update as well.
I
as
can.
a specific one.
Probably specific is better. There's two things that have occurred. We have included in the Q2 contract language that would preclude Mr. Kane from participating in any way, and also specifically brings the whole entity within the same provisions as the commission with respect to speech, if you will, outside of the redistricting process. For the same reason that the statute limits specific comment about any particular district for commission members, we want to make sure that those drawing the lines have that same obligation. Now, that doesn't preclude them from talking in general about redistrict, and they were particularly concerned about their responsibilities as employees of the state data bank from being able to speak to the data bank and what it does and how it works, but not to how a district might change. That, it seems to me, is what the statute is contemplating is off limits for the commission. So we have agreed on that language. The other thing that's important, as a result of our request that be included, Mr. Kane has decided to actually leave Q2 as an owner. So I think while that wasn't something we had requested, his ownership interest there has been the subject of some commentary, and hopefully that his decision will address that as well.
So the firewalling at this point is... So the firewalling is really not necessary because he's no longer part of Q2.
I think that's right, although a case could be made that in the absence of it, he would still have access to the firm, and that could be problematic for the commission. So they've agreed to retain the language. I think it has less meaning as a result of his decision to leave.
Okay. Well, that's helpful information.
That's worth noting.
Okay. And so we'll report that back to the full commission. So, and I raised this question because partly because of some preliminary discussions that had occurred at last, and I apologize, I was not at last Legal Advisory Committee meeting, but there was some discussion, I guess, regarding Professor Kane, but that seems to be mooted out now because he's no longer with Q2. But I did have an underlying concern regarding First Amendment issues regarding the regulation of statements outside of the scope of work. Mm-hmm. And since Professor Kane, and I was most concerned about Professor Kane being sort of limited in terms of his speech, because he was firewalled, and two, he was also getting, it sounded like a restriction was going to be placed on his being able to talk about redistricting more generally, which I thought would be very problematic. But I get the question I sort of still have is regarding the outside the scope of work speech. Now, again, it sounds like Q2 was, because of their, or the majority of them having some involvement with the statewide database or the redistricting group at Berkeley, that they're still have some of those roles. I'm not sure how much has been sort of taken off their plate to be Q2. It sounds like Karen McDonald in particular is still the director of the statewide database and would still have that role outside of the Q2 contract. But it sounds to me like the restrictions are not so severe that they're prevented from talking about redistricting the database itself or redistricting matters more generally, as opposed to what they're actually doing on the contract.
You have stated that correctly. We expressly state that they can continue in their responsibilities in those other roles.
Okay. Because again, I'm just from my understanding of certain First Amendment case law, once you start restricting outside the scope of a contract, you're in big trouble at that point.
We had no desire to do that.
Yeah.
We agree with you, and that's what the effort has been,
Okay.
is to narrowly tailor it to the terms of the contract.
Okay, very good. Are there any questions for Mr. Miller at this point? Public comments before we go on? Yeah. Yes.
State your name and
Yeah.
spell your name.
Yes, my name is Raquel Vargas. It's Vargas, and I would like to make a comment in regards to the Bruce Kane and the firewall. First of all, you guys said that you were going to do a solid firewall, and now it appears that you're backtracking. And one of the only two reasons why the conservatives on this commission agreed to Q2 was, one, to impose the firewall and have it there regardless of him deciding to quit or not. That was one of the agreements. And two, it was so that they would also look at the actual well, basically, my concern is the firewall, okay, and that now you're backtracking on that. So.
Okay. Thank you.
Mr. Chairman, just
Go ahead, Mr.
clarify
Miller.
if perhaps I created some confusion. The language that the committee requested with respect to the firewall does continue in this agreement, just as discussed and as approved by Commissioner Filkins-Weber. It's just that in addition to that, Mr. Kane has decided to leave the firm.
Okay. Which again is beyond our control.
That's
at that
right.
point, but the firewall is still in existence. Okay. Okay. Any other members of the public wanted to comment on this issue?
I just want to make sure that Ms. Vargas understood what was just said, that our attorney just iterated again that the original language, the firewall language, is still in the contract with Q2.
You can come back.
Thank you.
Give you a couple minutes.
Thank you. Again, Raquel Vargas. Thank you for the follow-up comment. And then additionally, the second item in which I was trying to communicate was also that the second item that the conservatives on this committee agreed to Q2 with was whether or not there would be, was based on the fact that there would be a peer review. So that has not happened yet.
Okay. Thank you. And not being directly responsive to the question, but I believe the peer review question is still open for commission discussion as well as through the technical committee.
Well, we are proceeding with, I believe, Mr. Clayfield is proceeding with the.
He's developing an
RFP, RFQ, whatever that process is,
right.
for somewhat to respond to the commission if we have any questions with regards to Q2's work.
Right. And I don't. My recollection is we did ask him to sort of start the ball rolling in terms of developing some materials, and then we haven't finalized anything yet. Though we're still going to review that, but we wanted to at least get the process started. Given the nature of the contracting process being fairly lengthy, even the type of contract that he was discussing may be abbreviated, but it's still.
It is going through. The commission did approve to go forward with that.
All right. Okay.
So
moving forward with the staff developing some first materials that the commission would then look at, and then. So as I recall, we didn't make a decision we're going to hire a peer reviewer, right? That's still subject to discussion, as I recall. We initiated staffs looking into it so we could at least get to a point where we could vote on it, is my recollection.
Our understanding as well,
right.
if required.
all right, so that's still in the process.
Okay. But I think, again, it is moving forward.
Yeah.
but we haven't finalized that. Okay, very good. Let's see. Commission action. Number 3 was covered earlier. Number 4, we have. I think Commissioner Fickens-Weber had raised this issue. I missed the last meeting, so I'm not sure if this was something that she had wanted to bring up, or was it? It was regarding sort of limiting. My understanding is that just because of the nature of some of the online materials and websites, that it might be inappropriate for commissioners to sort of look at that because it might influence our decision making. Was that the concern? And I apologize because I was not at the last meeting, so I don't know.
I think that's a fair way of saying it. We've had some compromise in our ability to follow up with, for example, Q2 to work these issues because their contract has not yet been in place. Perhaps it's best to come back to the Commission with a more detailed report from them about those capabilities, although I think we do have a local expert in Commissioner Baraba who was not here at our last advisory committee. Would you be able to comment or lead some insight into how the commissioners might properly use some of the map-making tools that are available in connection with their preparation for drawing maps?
I'm not sure. A lot depends on the commissioner. But the software that is currently available either at any of the sites that were put up by the Irvine Foundation is certainly anybody can go to that. I think Peter Yao said he was scheduling some time over to go to the one in San Bernardino, I think. And there are people there who actually would allow you to help you do that. And there was just another submission that we're putting forward that came out of the outreach committee that's ESRI, which is another software company, is making stuff available again at looked like a pretty reasonable price to me. That anybody can go to those sites and do it. Now, it's going to be easier for some people than others because it's a complex activity. I would recommend anybody who wants to go do it who hasn't done it before start with a district rather than trying to do a statewide plan or do a region because that's a very large database when you start doing the whole thing. But there's plenty of capability out there for anybody who wants to go forward. Yeah. And we're going to hear then from Q2 as to what they're going to make available and to the commission. And but that I don't think we've worked our way through that yet.
So I'm still not entirely clear what the underlying concern is, and I understand again that depending on which website you go to, there may be again certain directions that they may be pushing, and I understand that, but. And I'm curious about what's happening at the assistance centers in terms of. I have no real interest in sort of doing the dirty map drawing myself. That's why we hired a consultant. But I'm curious about how they're doing it and how they're interacting with the public. I'd like to see how that is working. I mean, is there a very strong concern that again, if commissioners were to go to an assistance center or look at certain sites that might affect might bias them in one direction? Is that? Well, I'm not quite clear what the underlying concern is here.
Not sure either.
I'm not, is the concern that somebody at these sites is...
I'm sorry, your mic.
Is there some concern that somebody at these sites is directing people to draw districts the way the person at the site wants them drawn? Yeah.
Well, I would have a problem if I were sort of sitting there looking over somebody's shoulder while they were drawing a map that they might present to me later. That's a problem. But if I'm just sort of seeing how are you guys doing? How's your operation run? How's it going? I think that's appropriate for fact, just sort of so we have a good sense of that. But I don't think that's required either. We don't all have to go to the assistance center.
Based on the criteria that at least I've observed is the group that's putting it together, which kind of grew out of the statewide database community, it would seem to me I'd be a little bit startled if there was a programmatic plan in place to mislead the population with the data. And if it was, I'm sure somebody would pick it up in a nanosecond.
Yeah. And actually, I think it's something we might want to know if to the extent that there was any problems with any. And again, we can assume the public can sort of figure some things out, but other things may escape them, as it might escape us as well. That there might be some issues there, but I can't think of any that would immediately come to mind in terms of having to sort of say, "Oh, stay away from that website or stay away from the assistance site," because they're going to make you. They'll draw the maps in a certain way that you don't really reflect what you want.
Well, I did go to the San Diego assistance site and spent about an hour there, and it's very helpful. It's a very user-friendly site. They have someone there that's there to assist any public member to come in, and I have printout material that happened there, and it was helpful for me as a commissioner to see how that operates, and I can tell you, it's a very user-friendly public venue for people to learn how this process works with Maptitude, which is their software, and it was helpful for me to see how Q2 is going to do our work.
Okay. And I think we did have, I believe, Mr. Wright, who attends many of our meetings, I think, comment. He had actually attended a session and reported positively on that. Yeah, Kamaya.
I guess we're operating without knowing exactly what Commissioner Wilkins-Weber was concerned about. I guess there's the possibility that you would be, if you were going to the centers, you might be approached by people or have to deal with some inappropriate contact in that way. But I really think it's our responsibility as commissioners to inform ourselves to the greatest extent that we can, so that when we are actually engaged in the process that we're here to do, we have as much understanding as possible. And I think that goes, again, to addressing what seems to be a great deal of concern in the minds of some people in the public that, we're going to be simply following what other people tell us to do.
Okay. Any other comments? Any of the members of the public who wanted to comment on this issue? Okay. Let me move on then. So, racially polarized voting analysis. Now, this obviously is an issue I think we would want to consult with our Voting Rights Act counsel regarding the scope of work for some technical consulting on polarized voting as well as other data that we might need to help us with Section 2 and Section 5 compliance. Is that, again, Mr. Miller's pretty much had the discussions with Gibson Dunn. I don't think any of the staff or the commissioners have actually been working with them yet. So has this come up at this point in terms of some discussion?
It's come up, but it has come up, but not in a way to set the foundation for a decision. It's very important that the lawyers come and appear at our next business meeting, which they'll do. And you might want them to come to the committee meeting to have a discussion about this. If it's the sense of the committee, it can wait until that time. We had originally anticipated having them here today, but because of the contract issues, felt it was not the right thing to do. This is something that I can and will talk to them about during this month in anticipation of the meeting, and would suggest that they have that discussion with us, either in the committee or the full commission, when we meet. Does that timing seem satisfactory to the commission?
I think that makes a lot of sense. I had some just to convey to you maybe things you might want to ask them about. I think for this particular question, it has been budgeted, but I think it raises a lot of questions regarding how much we have to do as a commission in drawing lines versus what is normally done in litigation. And my assumption is that we don't have to reach the level of detail or the breadth of analysis that you would normally see in a Section 2 case, for example. But we have to do something. And we just can't just sort of say, either rely just on public testimony or just sort of say, oh, well, there's racially polarized voting going on in the world, and therefore we can draw a majority-minority district just based on that, just based on the census numbers. I don't think that's sufficient. But somewhere in between, just sort of saying, well, there's probably still some stuff going on, and some very detailed studies that would have to be conducted for every single district where a Section 2 violation might occur, which I don't think we have neither the resources nor the time to go to that level of analysis. It would be helpful to get a sense of where in between those two ends of the spectrum do we need to be. So, for example, should a consultant do a fairly lengthy sort of literature analysis, or look at past litigation or recent issues that have come up that doesn't require any new studies, versus having to do some sort of new analysis either via the statewide database or some other data set. And that, of course, saves you a lot more money. If you aren't doing any new analyses, you're looking at older ones and drawing certain conclusions that will allow you to say, well, in this particular part of the state, we have some problems, among other things, in terms of polarized voting, and therefore that may be the predicate for a potential Section 2 case, and given the numbers and the population data, it makes it appropriate at that point to do a majority-minority district. So that sort of analysis, I think, the analysis by the law firm would, I think, be very helpful, so we can get a sense of what we really have to do and what we probably don't have to do to comply with the law.
Commissioner Anchetta, where would we possibly apply the racially polarized voting analysis? Under what conditions?
Sure. When we're looking at both Section 2 and Section 5 of the Voting Rights Act, we're looking at certain legal standards. And in particular for Section 2, because we're, and this is number 2 on our big list of criteria, so it's one of the leading criteria, we have to look at vote dilution and not diluting minority voting rights through a variety of ways. And Anna Henderson covered some of those at our last business meeting. And in essence, among the several criteria you have to look at, including population data, size of a population within a particular proposed district, you really have to look very carefully at whether there's racially polarized voting. In other words, if you divide a community because of the polarized voting problem, in other words, as an example, let's say Latino voters typically tend to vote for Latino candidates. White voters in the same district tend to vote against Latino candidates, and will support, let's say, white candidates. That may be sufficient evidence of polarized voting, that if you, let's say, divide up a Latino community, where it could, in fact, have a majority that could elect a Latino official, that could be a violation of the Voting Rights Act. So there's a whole bunch of other factors that need to be looked at if you're suing under Section 2. But for our purposes, we have to be sure that we have to look down the line and basically say, well, are we creating districts that might, in fact, be subject to Section 2 litigation? This is the harder part about our analysis, is that we can't sort of say, well, here's the law and just apply it. We have to be sort of anticipatory, because a Section 2 violation isn't just sort of there. We could possibly create a problem, and then somebody has to sue us in order for there to be a Voting Rights Act violation. We just don't necessarily, or we're trying not to violate them sort of up front. So we have to make sure that we're thinking about what could happen down the line if somebody were to sue.
So if our VRA consultant is guiding us through this process, would it be incumbent upon them at some point to point out that we may have a racially polarized decision that we've made? Will that lead come out of our consultant?
Well, I wouldn't call it a racially polarized decision. What we're looking for are, and by the way, there will be plenty of public testimony that says here's probably going to, you have to draw a district a certain way because you might have a Section 2 violation. So we'll get help on a lot of these things, but we should certainly have an independent analysis of what's going on. That's the most important thing. But there will no doubt be certain districts where you could draw a majority-minority population, and because of the existence of racially polarized voting and a few other issues that come up in terms of potential violations of the Voting Rights Act, that we should probably draw a district a certain way, because if we do it differently, in other words, let's say we divide a majority-minority population in order to keep a county intact, let's say, we would have a problem, because we could have a Section 2 case somewhere down the line.
Now, is it always necessarily a black and white racial thing?
When you say black and white, you mean
Racially polarized? Could it be, let's see, black and Latino communities that have a sense that they're not having a fair lines drawn here?
Right, yeah.
How do you apply that there?
Well, it can get complicated. You might have what are called possible coalition districts, which are usually referring to different minority groups that might be combined to form a majority-minority district. So, again, an example would be a black Latino coalition district. There's still a little bit of question in the law about whether that's a viable claim. We'll have to confront that, I think, in terms of how we're looking at the problem. Our VRA counsel, I think, will give us some advice on that.
That's what I want to make sure.
And there may be circumstances where, in any particular jurisdiction, there's some interesting voting patterns. Where, let's say, for example, you could have a Latino Asian coalition in one district, but in another district you might have Asians and whites vote a certain way and Latinos vote another way, and it's what you think might be a combined district is maybe not what you thought, because the voting patterns are different. Now, again, the challenge, of course, is that if you're thinking about drawing 4 statewide maps and all the possible districts where this might occur, it's a lot of analysis. That's the big challenge for us, because if you really want to get deep into it and you had another year or two and the money to actually do all the analysis, you could have a very thorough analysis of all the state districts we could draw. I think the problem for us, one of the big problems, is we don't have that time or the resources to do that level of analysis. We're going to have to make some projections based on more limited data.
Now, this analysis that you're mentioning, what form does that take?
Well, don't want to get too technical here, but there's different statistical techniques that are often used. So, for example, I'll give you the 2 big ones, but this is getting really technical. But one is what's called homogeneous precinct analysis. Okay, that's where you look at a particular area where it's very heavily composed of voters of one race. Let's say you go to a district that's 95% black voters. And you just sort of look at the voting patterns of voters in those districts. And that, if you pick enough homogeneous precincts, like 95% black, 95% white, you can get a sense through an inference of what you get from that data that, well, there's probably some polarized voting going on here, based on who's actually voting for whom. That's one technique. The problem with that technique is you can't always find districts like that. There are some, but most districts in California don't look like that. So you don't have the homogeneity that you'd like. The other technique is a technique called ecological regression, which is a really complicated advanced statistical analysis where you are looking at a variety of data that you can get, but you're drawing inferences about how individuals are actually voting based on more general patterns. That's why it's called ecological inference. You're sort of looking at the big picture and inferring individual behavior based on the big picture. And it's an accepted type of study, but it's not without controversy. And mathematicians and statisticians and social science have been trying to figure out better ways to do it, and there have been some breakthroughs in certain techniques over the last 15 years. Needless to say, it takes a long time to do it. You need a lot of data, and it doesn't always lead to precise conclusions because of how you can define. Well, I don't want to get too technical, but you can define. When you do any kind of statistical analysis, you can define the problem a certain way that might lead to very different conclusions. So there's always, which is why you can have different expert witnesses saying different things in a lawsuit, because they sort of work with the same data, but they come with different conclusions. So, needless to say, very very technical stuff. We need to have somebody who can kind of shepherd the commission through what we need at a more basic level to say, okay, is there a problem here? And if so, should we address it by drawing a minority district? If the data is incomplete or we don't have data, we may have to simply say, well, can we look at the other criteria? Maybe Section 2 really isn't at stake here, but there's other interest or there are other considerations where you could still draw a compact district that's preserving some other municipal boundaries, or there's a communities of interest or neighborhood criterion that might fit in. But again, it's really hard because we have a few months to do our job, and this kind of stuff would take you literally months to actually do all the analysis.
Yeah, but it's right around the corner.
All right. So
Going on to Southern California. So I guess what I'm hearing you saying that this is going to require teamwork ourselves, being vigilant. We've got a VRE attorney who's going to be consulting and obviously pointing it out if he sees it, and we have Q2 running the numbers and the maps to help us collectively see where we're going with this.
Yeah. No, I mean, again, I think we should follow the lead of our two consultants here, and I mean, Q2 as well. I think that they have a lot of they have a lot of data in their database, obviously, and they know what can be done with the data. And a lot of this information can be gleaned from, not all, but a lot of it can be gleaned from the statewide database.
Okay.
But somebody's got to crunch the numbers. That's
Well, this is very helpful because this is kind of new, Sarah, and I'm trying to get.
No, and trust me, and this is certainly not something most lawyers have exposure to. This is why this is a very specialized area.
Yeah, I would just say, in some cases, you may be better off by not knowing the details of it, because many of these techniques have heroic assumptions underlying the process. The other thing that's kind of makes it more difficult for us is that most of these voting right district areas were created when we had military bases sitting in those areas, and so you had a lot of people in the area but not voting there, and now all those bases are gone. I think all those bases are gone.
Yeah.
And so it adds a level of complexity to the reality of what we're facing.
Yeah, I mean that's actually the case for our Section 5 counties. Is that if you go back to when they actually were covered by Section 5, it's not because of minority, because actually for some of them the minority populations were quite small. They're big. A lot of them are quite bigger now. So there's a whole bunch of issues now. But when they originally were determined to be covered by Section 5, it was not because of big minority populations and problems in those problems of discrimination as much as it was military bases where personnel didn't register there and vote there. Because the triggering formula looks at sort of depressed registration and depressed voter turnout, which in a lot of places is all about discrimination. But in California, it's, at least from the initial issue, was about the military personnel more than the minorities. But now, again, we have particularly kind of like Monterey County, where there's quite a large minority population. There's other things going on. So,
Interesting.
But a lot of interesting history there. So I'm sounding like a professor again. That's what I do. That's my day job. Sorry. So any other questions regarding? Again, I think we do need to move forward on advice of counsel and Q2. I think we should have a good plan in place. And I think is Mr. Claypool or is the staff sort of starting to develop at least the templates that we might need to follow up with in terms of a contract? Or going through the contracting process.
The one that's among others, the one that's closest to this is the inline peer review. A contract for a social scientist of someone of that type, who I believe is who you contemplated would do this work. Is that correct?
Yeah.
That one has not been developed.
Okay. And again, I would simply just make sure that we want to make sure that Gibson Dunn is working closely with Mr. Miller on giving us some informed or something to inform our decision making.
It might be Do you feel it would be premature for the commission to request that work to be done, or would it be better to get a report back on advice on that subject before we start to prepare an RFP for such a person?
Well, I guess the problem is that if you really need to do some analysis, you need to get it started quickly. If our sense is we have to sort of work with what's already out there, which I think my sense is that's sort of where we have to go, because I just don't think even if we wanted to, I don't know if we can necessarily get new studies conducted in time to inform our first draft. But I think it would be good to at least get some clarity or some initial signals from the firm to say this is something we need to sort of get in motion if we're going to. But obviously, even if we're just looking at a literature review, that person needs to be on fairly quickly because of wanting to get the first drafts together.
I mean, I would concur, and I think so, if nothing else, because of the slowness which the process of getting someone on board takes. You sort of had to have started last month.
Right.
And so I agree. I think that it would behoove us to begin the process of identifying what we want. Now, that will be in consultation with our attorney and I think our line drawer.
Right.
But I think we should get underway with that as well.
Is that an individual the commission would want to interview and independently approve?
As a hiring?
Yeah.
Or as a consultant?
Do we want to do that?
Well, that's a good question. I think my initial sense is we probably would want to do that, but again, it's something where we would probably defer a fair amount in terms of recommendations for what the scope of work. I think we might defer more to counsel and Q2 on that.
I mean, I would agree, but I think that is something we probably would want to talk to, because in some ways they're like Q2, they're like the Voting Rights Act attorney. They're going to provide us with specific assistance in something that we need assistance on.
And I think we'd have to vote on it, certainly.
Yeah.
I think it would require the typical supermajority vote. But again, how deep do we as commissioners have to go into?
I think our job is not. I mean, I couldn't make a good judgment as to the depth of the stuff. I'd have to take recommendation, but I think I would at least want to be able to have confidence that they would, reach at least a threshold level. In my understanding.
Right.
If we could, it might be appropriate. We could let the technical advisory committee take the first look.
Yeah, and I think that was probably on one of our several agendas.
I think it's in that agenda someplace.
Yeah, someplace. So we can sort of take a look at it.
When you say take a first look, I'm not sure what you mean.
We identify potential candidates and interview them to see that they're qualified and make a recommendation to the full commission.
Just keep in mind that at least on a scheduled basis, that committee would not be meeting before the end of April.
But the engagement of this person doesn't have to be even before the first maps are out. I mean, it's really engagement gets when we get closer to the final maps, I would think, because we're going to get the feedback on on some of these initial maps.
Yeah, I'm not sure I agree. I would think that we want them at least for the first round of maps. And I say that because the more good data you get on the front end, the better your draft maps are going to be.
Yeah, I would agree with that.
We could create a special committee, I guess, somehow to take on the assignment.
We can do that. It would have to be noticed. Now, of course, we can notice that committee to meet prior to the end of the month at a special meeting.
Right.
Yeah.
Right.
But I think you're right. It should come out of technical advisory, because I think that's what this is.
Yeah, we could have the technical advisory committee meet at a separate meeting. That would be allowed, I would think.
Yes, as long as it's noticed that we can do that.
Yeah. You could even do it maybe at one of the outreach meetings.
I believe that, but I'm not sure of this at all. I have a vague recollection of that about $150,000 was suggested for this work. Does that sound right?
Well, it depends what depends on what you're going to be asking the person to do. But there's a lot of people out there who have spent a lot of time in this area who are very interested in the subject and have strong academic backgrounds. That might be more than that might be sufficient.
Yeah, and I mean, you might recall from the Rose Institute application that remember there was some confusion about whether there was a subcontractor, but that was an example. At least a Handley was an example of an individual who does exactly what we're looking to do. Again, that's just an example.
That's list, and we could just work right off that list.
Yeah.
I know some of them they were very, very qualified.
Does that sound like the right placeholder number?
I would think so.
150,000.
I think that sounds right in terms of the dollar figure.
That's half as much as the law firm just for this subset of work.
I don't think we would spend more than that.
Yeah, I doubt we're going to go that high.
Unless we got into a situation where we really had to go to work at it full time.
Right.
Yeah.
So I would say when it's not to exceed things. Yeah. But I think we would spend far less if we do our job right.
Let's see. So perhaps this committee could bring forward the recommendation to the full commission that we undertake to identify this individual and request that a special meeting be noticed to the Technical Advisory Committee to consider applicants once identified. Does that sound right?
Mm-hmm. Sounds right. Andre, you okay with that? Yes. Yep.
Fortunately, I think three of us on the technical committee are actually here. No, we're not.
Except the lead, that she'll go along with it.
Okay. So actually, this question for Mr. Mill, which is somewhat related to this. We have a number of noticed business meetings, but and also we don't want any surprise meetings in terms of business. But if for some reason something does in fact come up, are there ways of accommodating? Let's say the commission just needs to meet for a half hour on something, and it's something we really need to do now, because if we wait too long, it's going to be a problem. Because we do have all these input meetings scheduled, and some of these, again, have noticed business meetings, but is there some sort of little catch? Is that a problem with Bagley-Keene if we do that?
There are challenges, certainly. That's why we've noticed a lot of meetings is to try to have those slots available in part for exactly the purpose that you're suggesting. The 14-day requirement is very broad, and there's really no way around that. Our best way to accommodate that is to notice perhaps more meetings than we think we'll need and then cancel them.
I mean, Commissioner Hunt, as chair, do you think that's something we might want to take up, whether we just simply, again, notice more business meetings and just, again, if we don't need to, we just simply cancel them?
Yeah, I think that's been our strategy from the get-go. There's always some surprise element that pops up, and so this gives us the flexibility to call that meeting if necessary, so I think that would be a wise decision.
Okay. Is this something we should bring up from the committee, again, since you're chairing,
Sure.
Can you just bring that up as part of the agenda? Okay.
Yeah. I don't have the calendar here. I mean, one thing we could do would be, is there a mid-month meeting that would make sense to notice with the idea that it would just be for contingency purposes?
27th and 28th.
27th and 28th.
We have those days noticed, don't we?
Yeah.
And so the question would be, are there any other days between now and then purely for contingency that we should notice?
They have a call into the week that we left out.
Okay.
Yeah. And the next would be May 5th and 6th. Business meetings that are already on here.
So it looks like we've done what we can to address that, and it might even make an additional meeting of the Technical Advisory Committee difficult. If looking at the calendar, that seems to be what you're saying.
But we could meet on the 20th or 28th. And
Sure.
It's already scheduled.
Sure. But that's already a scheduled meeting.
Yeah.
That item was on our agenda for today's technical/outreach committee meeting. Inline process, scope of work review, and hiring.
That's on the agenda.
So that
I think we just ran
roll
out of time.
over.
We just ran out of time.
That'll just roll over to the next meeting schedule.
Okay. Okay. So I have one more item on our agenda, which is the issues related to census adjustment data, which, again, I think was something the technical might have taken up, but we didn't. Is this having to do with the prison?
This is a carryover item. We discussed the prison issue, I think, as far as we could at the last meeting. It's really a placeholder item. There may not be anything for this meeting to discuss.
Okay. Where are we on, I mean, my sense is, and we've gotten some reports from staff regarding the prisoner issue, that the data is not particularly conducive to doing any kind of adjustment at this point, that particularly the state level prisoner data is, well, not very good, not very clean.
Right. The data as to where these people live outside the prison is just not there.
Okay. And was that settled at the last legal committee meeting, or was it?
I think Q2 covered that in their presentation to the full commission.
Okay. So this is gone as an issue at this point. Okay, that's fine. I want to be sure there's some closure on it.
Before we adjourn those, so we'll take this off for next, or we can leave it on if there's something to discuss.
Wouldn't hurt.
You can leave it on at this point, just like.
Are there other matters that occur to you now that you'd like to agendize for our next meeting?
Yeah. For the advisory committee?
Yes.
Can't think of any at this point. Again, I think there's some coordination with technical regarding the VRA voting analysis, but I think largely that can be vested in technical. I think we're just.
I don't know.
Yeah. Any other suggestions on just potential? Again, I think we're sort of moving in the phase now where we're just going to do all our input. Is sort of basically.
Maybe something will come out of our input meetings that, but as of now.
Yeah, and that's really the concern I have was why I thought we might want to notice a few more minutes, because we don't know at this point if some things will come up. There may be some very interesting issues that we just weren't thinking about that are very, very squarely on our radar screen.
It might make sense in that case that we notice a meeting 2 weeks from Saturday or Sunday. Just notice it for the Legal Advisory Committee. And if nothing comes up, we can cancel it. But we may get a.
Sir, I can't hear you. I'm sorry.
I think the problem is that is the week that we cleared out because it's right before Easter.
I understand that. But, I mean, it's one of the things, if we need the meeting, we might as well notice it. I mean, if we don't need it, we don't have to have it. But otherwise, we do end up at the end of April. What do you think?
I have no problem doing that. I mean, are there problems of that particular week, though, again, for those who celebrate Christian holidays? It's
and also
Holy Week.
Noticed everybody that was the week we're going to get everybody off. So plans have been made and by a lot of people.
Okay.
I mean, we could have a meeting, but my guess is some people are obligated at this point.
Mm-hmm.
Okay. I'd have no problem noticing it, but I don't want to speak on behalf of other committee members either.
This would be a full commission meeting?
No.
Just a
legal advisory.
But it's really, it's more of a contingency.
Yeah, that's what it is. I mean, I don't expect to need it, but I don't want to need it and not have it.
Right.
And, and if we're really waiting to get, I mean, we could wait till the end of April, I guess, to determine if we have to do this after we get to, to another set of input meetings.
Yeah. Well, why don't we do this? Why don't we, maybe we can bring this up in the full commission, because maybe if there's any other, we could notice a number of committee meetings, and we could suggest maybe legal, maybe we'll have Commissioner Blanco and Commissioner Wilkins-Weber when we do our, because we're reporting back on other stuff tomorrow morning, and then are we losing a day? Maybe 1, 2. Wow, we might be losing a day. What were the dates you were suggesting?
Well, just 2 weeks from
today, or
I think. I mean, we talked about the need to have perhaps that something will come out of the input meetings that will generate a need. Well, we have to have some input meetings to determine that.
Right.
Now, maybe it's 2 weeks from Sunday, or maybe it's 2 weeks from the following Sunday that we would schedule it. But.
Okay, so the earliest we could notice of it for any committee would be the 21st.
And so
that would have to be done tonight.
Maybe we want to do it on after the 28th, because we will have had 3 of our Section 5 meetings at that point.
That was my point, is that we're just going to have 2 meetings.
Right, and I think
and the other ones might add.
Yes, so what I think I would do is I would notice something like around the 28th or the 27th?
We have 2 meetings noticed, the 27th and 28th.
Oh, yeah, they're already noticed
Yeah.
as business meetings?
I believe that's correct.
Okay, well then, that probably takes care of it, so we just have to add to the agenda.
Okay. Okay. Any other discussion at this point? So we'll close it up with any public comment at this point, or is there any additional comment? And again, the full commission will be meeting in about 20, 25 minutes, so we invite members of the public to join us as well at that full meeting, which will be in room 437. Okay, so I'm sorry. Oh, did you have a comment? Yeah. Oh, come on up. I'm sorry. Forgive me for closing too early.
Yeah, my name is Yoshi, Y-O-S-H-I, Salaverry, S-A-L-A-V-E-R-R-Y. I'm just wondering with regard to the language in the Voting Rights Act and, what you all were saying about the specter of Voting Rights Act lawsuits, basically what the definition of a minority is, because the latest census data about California says that the population is about 40% white and 37.6% Latino. So, so basically, I'm wondering, if at some point the population that actually the largest racial population in the state is Latino, would Latinos be considered a minority according to the Voting Rights Act? Do you know?
Well, we're trying not to have direct questions answered, but if I can address that once if you're done with your comment.
Yeah.
Okay. So, and this is for the edification of the other commission members. So the Voting Rights Act covers 2 types of